No is the answer to both of the questions suggested by the thumbnail and title of this video. Those being, no, it was not believed to be an electric or even a hybrid vehicle that was the cause of the Luton Airport car park fire, but more on that a little bit later. And secondly, no, the car park is not negligent and therefore liable for all of the damage for reasons that we'll come on to in this video, because they didn't have fire sprinklers installed. But as I say, a bit more of an explanation in this video. So first of all, the initial claim that it was an electric vehicle that caused the fire was relatively quickly replaced with a claim that it was a hybrid vehicle, almost as if everybody wants it to be an electric vehicle that caused this fire. But electric vehicles are reported to be much less likely to catch fire than ordinary vehicles, notwithstanding that diesel obviously doesn't catch fire as easily as a petrol vehicle, but it is usually the 12-volt battery system on those vehicles that catches fire. Now, Bedfordshire Fire and Rescue Service have said that it was a diesel and not a hybrid or electric car that is likely to have caused the start of this fire. The chief fire officer said that there is no intelligence at this stage to suggest that it was anything other than an accidental fire caused in one of the vehicles that had not long arrived at the airport, and it was not an EV or hybrid. And again, emphasizing that it is normally the 12-volt battery system that is the culprit for catching fire. And just as a brief interlude, you might have noticed that I've set up a new channel, Daniel Shansmith. I will link that in the description below. On this channel here, I help you to understand law. On that channel, I hope to help you to build wealth. So if you'd like to join me, build wealth, check out my first video with what a barrister earns and what I earn as a barrister, linked in the description below for you to check out. And so hopefully I'll see you over there ready to build wealth. Now back to the video. So moving on to the car park itself, and is the car park somehow negligent? There are lots of comments in the comment section, and I quote, "It is a clear case of negligence on the part of the car park, and therefore they're responsible for all the damage." But that is not the case, at least in my view, and I'll tell you why. Because in order to establish a negligence claim, there has to be a number of things in law to be established before anyone or any corporate organization is responsible for a negligence claim. First of all, there's got to be some kind of duty of care. Now, that is relatively easy to establish. Usually, if there's any connection between two parties, there's going to be some kind of duty of care established in most situations. However, then there has to be a breach of that duty of care, which requires an examination of what the duty of care entailed in the first place. Clearly, if you go to a medical professional, they have a duty of care to give you accurate advice, accurate care, and prescribe the right things and do whatever it is they're doing with proper care and skill and all of these kind of things. And therefore, if there's a breach of that duty, then it must mean that whatever they did fell below the standards that are required or set in whatever setting it is in, and whether they've stepped outside of what would be expected in law in an objective or even a subjective perspective as to whether there is a breach of that duty of care. Now, let's say for a moment that we look at the car park and say, well, there's got to be some kind of duty of care because you're parking your car there. And a contractual relationship with the car park may give rise in many different ways to a duty of care. Let's say that that duty of care stretched to protecting your vehicle from fire risks. Now, of course, fire safety is a paramount concern, and there has to be fire assessments in all of these kind of public buildings, but that is the minimum requirement. But let's say that this duty of care that we've just said that they probably have is somehow breached because they didn't have these sprinklers installed, which are not a legal requirement, by the way, in all situations, but more on that perhaps in another video. But let's say that we said that there was a breach of that duty of care because they didn't have fire sprinklers installed. That is still not enough to establish a claim in negligence against the car park for two reasons, really. One is foreseeability of such damage, which is not entirely unreasonable. However, the damage itself must have been caused by the breach of that duty. Now, the damage caused is a vehicle catching fire. It is caused by either a pure accident, or in one previous case where somebody tried to blame an electric vehicle owner, was a deodorant spray that was in the back of the vehicle and it was in the sun and which exploded, which caused the fire. But in this particular situation, It's unknown yet as to precisely what caused it, just that it's not an EV or a hybrid vehicle. But that is the cause of the fire, one way or the other. It is not, for example, the lack of sprinklers in the car park that caused the fire. If you follow the logical analysis there, the damage to all of the vehicles and indeed the building itself was not caused by the lack of the sprinklers. Now, you could well argue that the damage would be far less had there been sprinklers installed. But that doesn't mean that the car park caused the damage by their negligence. That's simply not how a negligence claim works. Now, some people will ask about when you go to, let's say, a sporting ground or you take part in some kind of sporting event and they say you take part at your own risk and they try to contract out of any liability for things like that. One thing that they cannot contract out of is your personal injury by their negligence. So if a company is negligent, i.e. there's a duty of care, they've breached that duty of care, which means that they are negligent in that sense, but for liability to be established in negligence, it must be caused by the negligence. So even if you suffer a personal injury, if it is not caused by any such negligence, then the negligence claim will fail. But if they were negligent in the case that there's a duty of care, they did something that breached that duty of care, and that negligence caused the damage or the injury, which is something that they cannot contract out of, because a company cannot contract out of injury or death, then if that is caused by the negligence, then there is a claim to be established in negligence. But in this situation here, the mere lack of one of the many possible safety precautions which are not yet a mandatory requirement in this particular scenario, at least insofar as I've read, then there will not be a claim established in negligence. Now, there is a caveat to all of this in that in many situations like this, many catastrophic and large-scale events do very often result in a change in the law. So in this situation, it is entirely possible that there'll be a whole analysis of it, and the conclusion might be a change in the law that requires car parks such as this one with a certain amount of cars in it perhaps to have a sprinkler system installed. It certainly is the case for large-scale open buildings or residential buildings above a certain height with a certain number of people in it. This was the whole argument with the Grenfell Tower disaster, whereby the building was built before a certain date, which then did not require sprinklers installed, and only after a certain date it did. So now any buildings built after a certain date with a certain height and I think a certain capacity of people living in there need to have these sprinkler systems installed. But the car park, currently, they do not, at least insofar as I understand it. But as I say, this is one scenario where it might result in a change in the law. But there are the two questions answered. The fact check at the moment suggests that the fire chief himself said that it is not caused by an electric or a hybrid vehicle. And in my view, the car park is not going to be responsible in a negligent claim for the reasons I've outlined in this video. If you found that useful, please do give it a big thumbs up and subscribe, and I'll see you next time.